Hello landlords, it's Ernie Garcia, landlord attorney, and today we're talking all about that B word, bankruptcy. Let's get started. So from time to time, it happens that you file an eviction and your tenant, who is having a hard time paying not just your bills, but all sorts of bills, right in the middle of the eviction process, files for bankruptcy in a federal bankruptcy court. Now, your case is raised in a state court. In the state of Texas, it starts off in the Justice of the Peace, and if there's an appeal, it moves on to the county court. So whether you're in the Justice of the Peace court or the county court on an eviction appeal, you are still stuck having to abide by the Superior Court, which is the federal bankruptcy court. And the reason that this happens is because the federal court does have supremacy based on the Constitution over the state court proceeding. And what happens when a tenant files for bankruptcy is that the judge in the bankruptcy court issues what's called a stay. And that stay essentially is a big pause button, boop, that the court presses and says, look, everything stops. All collection, anything having to do with the debt, certainly any lawsuit is on pause, on hold, until the bankruptcy court says otherwise. So what does it mean, in terms of your interaction with the tenant? Well, you certainly can't go and request rent because that's a debt, and all debts are subject to the bankruptcy and are put on pause by the court. And so you cannot make any additional efforts to collect a debt, but you also can't move forward in any court proceeding, particularly ones that involve debt. And so, whether you're willing to waive the debt or not in the eviction court because you're more interested in possession is irrelevant, because the county court or the Justice of the Peace no longer have authority to act, not for as long as that stay is in place. So how should you respond then? Well, it is possible for you to have that stay lifted, that the issue of the debt is not in question and that all you're seeking is possession, but you would need that stay lifted by the bankruptcy court. Remember, the county court nor the Justice of the Peace can remove the stay. Only the bankruptcy court can do that. And you can make that request, and if in fact the bankruptcy court allows you and removes the stay for purposes of the eviction, then you can proceed. But until that happens, you're just stuck. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. So then what do I recommend you should do if you find yourself in the middle of an eviction and your tenant has filed for bankruptcy? I strongly urge you to seek out a bankruptcy attorney, particularly a creditor's attorney, because generally speaking, bankruptcies involve a creditor or a debtor. The debtor is the party that files the bankruptcy. The creditor is the party that is subject to the bankruptcy. And so in this case, as the landlord, you are deemed a creditor of the debtor who filed the bankruptcy against you and others in the bankruptcy court. And so if you find yourself a creditor's attorney, and really, you can ask any bankruptcy attorney if they can help you, but particularly a creditor's attorney with experience lifting stays in the bankruptcy. If that bankruptcy attorney reviews your case and says, yes, based on your specific facts, we can ask the bankruptcy court to lift the stay. However, you're going to have to wait X number of days, which is never going to be good news, but certainly part of the deal is there's a certain amount of time you're just going to have to hold your breath and wait it out. If it turns out that the bankruptcy was filed in bad faith or without any kind of merit, or that the tenant has never been a good candidate for bankruptcy, it's best to talk to somebody who deals with this on a day-to-day basis. And so your landlord attorney might not be able to do this, but certainly a bankruptcy attorney who handles bankruptcy cases, particularly on behalf of creditors, can review the facts of a case and give you a good time estimate and a good strategy for resolving the stay that's currently in place. If it turns out you've got a bankruptcy filed, go and find yourself a creditor's bankruptcy attorney, start asking questions and see what you can do to get that stay lifted so that your eviction can move forward in the eviction court.